Hello, everyone. Welcome to Omega Materials. We're excited to welcome you all. Before we begin, a quick overview of the presentation, as we will be covering every aspect of being a human resources manager in accordance to labor laws, protecting the company, and also protecting the employees. We as human resources managers must utilize a proper work structure. So we have a responsibility to maintain orderly workflow as well as being knowledgeable about labor laws in order to protect the company as well as its employees. So it's important to understand who we are as human resources managers. We must be well versed in these laws when it comes to situations regarding disciplinary actions, safety related issues, as well as compensation and potential layoffs. All these different aspects of the workplace safety and policy must be understood in order to bring a productive and positive environment. So some laws and accordances to keep in mind during recruitment, or just in general, are the Age Discrimination and Employment Act of 1967. So choosing candidates or when dealing with disciplinary or termination factors, we must keep in mind that it is unlawful for an employer to fail or refuse to hire or to discharge any individual or otherwise discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment because of such individual's age. So basically, we must keep in mind that we cannot discriminate against anyone regardless of their age. Because of this act, we must also be willing to accommodate accordingly. To limit, segregate, or classify as employees is also wrong in any way which would deprive or tend to deprive any individual of employment opportunities. We cannot limit an employee potential. Their age cannot hinder any chances for leadership opportunities or promotion. Also, we must keep in mind we cannot reduce the wage rate of any employee in order to comply with this chapter. This is a no-brainer. It must be reiterated that we cannot tamper with compensation regardless of their age. The Americans with Disabilities Act of 1990 and the Equal Pay Act are two labor laws and protections for the employee that must be taken into consideration. ADA is a civil rights law that prohibits discrimination based on disability. It affords similar protections against discrimination to Americans with disabilities, such as the Civil Rights Act. Um, when setting up forms for pay, keep in mind the Equal Pay Act. So no employer having employees subject to any provisions of this section shall discriminate within any establishment in which such employees are employed between employees on the basis of sex by paying wages to employees in such establishment at a rate less than the rate at which he pays employees of the opposite sex in such establishment for equal work on jobs, the performance of which requires equal skill, effort, and responsibility. Please familiar yourself well with these labor laws as they are crucial to keep the company safe from legal predicaments. These two labor laws go hand in hand when it comes to recruitment, uh, equal pay as well. So make sure that when we are going through the recruitment process, we are taking both these labor laws seriously, as well as promotion, growth, and termination. So the wages of the Fair Labor Standards Act. These laws protecting the wages and hours of employees are regulated by the U.S. Department of Labor. The main statute, which is FLSA, has a number of important functions. It establishes minimum wage, overtime pay, record keeping, and youth employment standards affecting employees in the private sector and in federal, state, and local governments. Covered non-exempt workers are entitled to a minimum wage depending on the state. So it is important to research in accordance, especially with us dealing with multiple um, facilities throughout the country. So unless exempt, employees covered by the Act must also receive overtime pay for hours worked over 40 in a week at a rate not less than time and one half their regular rates of pay. So overtime is a very crucial aspect as well when paying our hourly employees. Termination and disciplines are a more of a harder subject to cover, as well as a harder for us as human resources managers to carry out. But it is an important function of the company. Also, when dealing with these terminations, it's important to factor in the labor laws and making sure that we are not violating anything in terms of the Civil Rights Act, in terms of the Equal Pay Act, in terms of the ADA. So please research thoroughly and making sure that we are not stepping on the toes of any of these labor laws. As I said, being familiar with the termination process and labor protections is crucial. These certain laws must be abided by if attempting to discipline or terminate an employee, whether it's attendance related, performance, or situational. Um, please make sure that we are abiding by these laws. So a good point is that human resources managers and employee supervisors should carefully measure the individual's poor performance or non-compliance against company policy long before the termination discussion. Anything involving termination should be um, attempted to be resolved, attempted to be communicated with the employee before um, beginning the termination process. So an important act that we must be aware of is the Worker Adjustment and Retraining Notification Act, otherwise known as the WARN Act. So the WARN Act helps ensure advance notice in cases of qualified plant closings and their mass layoffs. The U.S. Department of Labor has compliance assistance materials to help workers and employers understand their rights and responsibilities under the provisions of WARN. The rule of thumb is, in events of a company layoff, we must provide a 60-day notice to our employees, and the unlikely but very realistic events of a mass layoff. The Family and Medical Leave Act. It's protected leave for employees. So essentially, it entitles eligible employees of covered employers unpaid job protected leave for specified family and medical reasons. Um, eligible employees are entitled to 12 work weeks of leave in a 12-month period for the birthplace of a child, the placement with the employee of a child, to care for the employee's spouse, child, or parents, any serious health conditions that make the employee unable to perform the essential functions of his or her job, any qualifying um, situations arising out of the fact that the employee's spouse, son, daughter, or parent is a covered military member on covered active duty. So please familiarize yourself with this act as it will pertain to protected leave for the employees. As we near the end of our presentation, it's important to familiarize yourself with workplace and OSHA laws. Workplace safety is essential to a good environment for the workers to feel comfortable and safe in. It is also good for the company to familiarize with these policies and to ensure that protections are there. Investigations will happen in the event of any injury, and that we continue to move forward with focusing this as our number one priority in order to prevent any further or any potential causes for violations of workplace safety. Scary, but they are very realistic. So it's important to see the statistics and to see the facts as these are real things that happen in the workplace. These are not made up numbers. These are not things that we talk about as if it's some myth or legend. These are statistical numbers that point towards failures of workplace safety. So we must keep this in mind when regulating our employees and their work environment, not only for themselves, but also for the safety of our company. Reading these statistics points towards real life numerical evidence of failings in the workplace. Reducing that number and preventing it from happening in the first place is the goal of our policy. So the Occupational Safety and Health Administration, otherwise known as OSHA, was put into place to protect workers from serious harm or death at work. This law requires all employers to provide workers with conditions that are relatively safe and free from known risk. The Act created OSHA, the administration responsible for enforcing rules to this effect, as well as providing assistance, training, and information to employees and employers alike. The only employees not covered by OSHA are public employees, those who work for state and local governments. But if the state has an OSHA-approved program, these employees are covered by OSHA Act protections. There are 4 states that fall under this umbrella: Connecticut, Illinois, New Jersey, and New York. The Virgin Islands are also in this category. All federal agencies are required to carry health and safety programs which meet private employer standards. To wrap up this presentation, as we can see, we have many different tasks and responsibilities as human resources managers. We must all be attentive to every aspect of the role: labor laws, recruitment, payroll. These are just the surface level of things that we must handle. So it's important to stay up to date with these laws and have a good foundation when it comes to these things, because having a good understanding and having the technical knowledge of these laws and how it could be applicable to situations will help us make decisions as we continue to move forward. Thank you for coming to the presentation, and good luck.